particular event. And just to give a quick context or brief context of why we're here, if you look at the issue itself, we're talking about the arrest of, I think most people here would already know. There is somebody we refer to as the BK16, who are 16 activists, writers, intellectuals who have been arrested or picked up under this particular law in 2018. And again, just a quick context why we're so concerned about this is the arrest is on grounds of an offense which is not linked to any action as it were. These are in some senses what we call thought offenses or offenses of thinking or offenses of ideology and belief. That's why it's a very specific kind of offense which people are being targeted under. And of course the scary part of it or the worrying part of it, how we choose to phrase it, is that for thinking certain thoughts or for believing in certain ideas, people are in jail of 5+ years. That's almost outrageous by any stretch of imagination within a democracy. Right? And that's the broad kind of a framework. Again, we go to who are the BK16. By now, everybody knows. I'm not going to go into the details of who the BK16 are. But the point being that till today, 5 years down the line, right? If you look at the entire what's happening, one person, of course, is tragically no more with us with his father's stand. We marked his death anniversary just a month or so ago. Uh, 5 people are out in jail with Vernon and Arun. It's 5 people who are out in jail. One person is under house arrest with Gautam Ravlaga, and then 9 people still in jail. Right. So there's still a lot of work to be done in terms of saying how do we get all of the BK16 out out there. That's the larger challenge before us. But I think what we want to look at in this particular moment is this particular judgment of Vernon Gonsalves' state of Maharashtra. And I think the broad point, which I think both Lupton and Radhika already on board, I know because speaking to them, is the idea that we see this judgment in some sense as really an outcome of a broader campaign which has resulted in this kind of a judgment. You have to create a certain kind of climate, certain kind of a mood, certain kind of a broader perspective, which allows for judges to decide the way they do. So there's something to be said for the larger public campaign in resulting in a judgment which has certain implications for the remaining of those who are still in jail. And I think the rest of the session will try and understand a little more of what the judgment is saying. So to try and get a little more understanding what the judgment is saying and saying what it can do in terms of taking the struggle forward to ensure that none of the other BK16 are still in jail. That's one part of it. And of course, there's anti-CAA protesters, right? Umar Khan and the others. That's the other big issue. Why are they still in jail? Again, a similar kind of a thought offense, as it were. And if we go down, we had a program looking at each state. Each state has its own stories, right? Of people who are in jail for nothing more than believing in certain ideas or being part of certain associations which are not criminal under the constitutional framework, but end up being criminal under the framework of the Unlawful Activities Prevention Act. That's a brief kind of introduction to the context. But now we'll get very specifically into the Vernon Gonsalves judgment, and I'll leave it to Radhika to take us to the judgment. Just a quick introduction to Radhika Chitkara, who's with the People's Union for Democratic Rights, which is I think you'd probably call it a sister organization of the People's Union of Civil Liberties, and based in Delhi. And again, if you haven't seen it, please do look at the range of reports that PUD has produced over the years. Really amazing and really fantastic reports which communicate a range of what's going on in this country, which sometimes we are not aware of, because the media doesn't tell us enough. And the value of a human rights organization, of course, is they tell you what the media might not tell you. And PUD's reports, of course, are exemplary in that particular context. And in the Vernon Gonsalves bail matter, they've done an excellent statement which I'm sure Radhika can share with everybody at the end of this session, at the end of this session. But now, without further ado, Radhika, floor is yours.
Thank you, Arun. So, I've been given permission to hold fort for as long as I want, and I think I'll capitalize on that a little bit. Obviously, it is a matter of celebration for us, definitely, to finally see Vernon Gonsalves and Arun Ferreira released from prison after 5 years. And as Arvind said, that the struggle is still incomplete. There are still 9 others that continue to be in jail, and that is only the tip of the iceberg when you begin to talk about the nature of political repression or the repression of civil liberties, speech, expression, association that we're witnessing in the country today. And so, of course, you know, talking about the overall sort of condition of civil liberties is not really within the mandate for today's talk. I think that would be far too much to take on. But I thought we could definitely talk about the UAPA through the lens of the judgment of the Supreme Court that was delivered on 28th July, which granted bail to Vernon, Gonsalves, and Ferreira in the Bhima Koregaon matter. As we know that this was a two-judge bench of Justice Aniruddha Bose and Justice Sudhanshu Dhulia, um, who granted bail to both of these persons on two grounds. One is the ground of what we call merits, right, which is that on substance, the court has granted them bail, and the other is also what we call the right to speedy trial, given that they've already spent 5 years in custody and the trial has not yet commenced. So, what both of these grounds are, I will talk about shortly. But also wanted to flag that in the same order, the Supreme Court also set a series of bail conditions which will shape sort of the quality of their liberty once now that they are actually out on bail and they are no longer in prison, right? And these conditions were then supplemented by the order of the special NIA court as well, which are very sort of troublesome conditions and cast severe sort of burdens on liberty even for somebody who is now out on bail. And this is also, I mean, this issue of bail conditions is also something that we've seen emerging over the past few years. Of course, even in Sudha Bharadwaj's case, there are also bail conditions, harsh bail conditions set on her. Siddiqui Kappan is now out on bail, again under the UAPA, but also subject to stringent bail conditions. If you remember, Zubair from the Alt News, who was arrested under charges of sedition, but was eventually granted bail. And Zubair is a journalist, and one of the conditions for him was that he cannot tweet. And the Supreme Court came down very heavily on those kinds of bail conditions, right? So I think this is also something that deserves attention, because so far we've been talking about how the UAPA is a draconian law and that it keeps individuals incarcerated for prolonged periods of time indefinitely because of its stringent bail conditions. And I mean, I think it's an outcome of our collective struggles that we've managed to make small inroads into this, into the draconian bail jurisprudence under the UAPA. But we can also see how that is now sort of pilfering into other parts of the law and other places where liberty can be constrained. So I think that is an issue that deserves attention. So I thought what I would do is, so there are a lot of significant pronouncements that the Supreme Court has made in Vernon Gonsalves versus State of Maharashtra. Some of which speak about the definition of offences itself. Okay, I feel like I should. So there's always like a tussle even within TUDR where sometimes people feel that lawyers take over the discussion and take over the conversation far too much, and I feel that this is that I'm going to be doing a bit of that now, which is to delve into a lot of legalese, but I'll try to make it as approachable as possible. So then we can do three things. One is to talk about the UAPA as a whole and why we've always called it an unlawful law or a lawless law or a draconian act, by focusing on the bail provision specifically. Then, after just giving a bit of a background about the UAPA, then we can talk about how this specific Supreme Court judgment sort of moves the needle a little bit forward, and then finally address the bail conditions towards the end. So just please bear with me with like a little bit of the legalese, but I can see that there are a fair number of lawyers here, so it shouldn't be a problem. Um, so, um, yeah, so as we know that, that UAPA is what we would call a special law in that it lays down some special kinds of offences, and it also lays down some special procedures to prosecute those offences, right? We know that this is a law that historically has disproportionately targeted religious minorities, ethnic minorities, and dissenters, and that continues the legacy of previous anti-terror laws as well, which is your TADA, POTA, and then you have the whole spate of preventive detention legislations before that. And the UAPA is able to act as such a potent tool for repression because what it criminalizes is not one individual or one activity. What it criminalizes is association, right? So there are, there is one chapter in the UAPA which talks about, unlawful associations. And then there is another chapter in the UAPA that talks about terrorist organizations, right? And what is different between an unlawful association and a terrorist organization is, there is substantive overlap between the two. But what really sets them apart is really the procedure that is adopted for their declaration, right? So, if for an unlawful association, you will still have a tribunal that will review the declaration. But for a terrorist organization, there isn't even that process. It is simply you declare a terrorist organization simply by amending the first schedule of the UAP. So you just have to add a name, and there is no review process on it. And then once you add a name of a terrorist organization, then you are a terrorist organization forever, right? So again, there is one chapter which will deal with offences related to membership or support to unlawful associations, and then another chapter that will deal with membership and support to terrorist organizations, which is still different from a third chapter which will deal with terrorist activities itself, right? So, we can think about the unfairness of a law in many different ways. We can say that a law is unfair when it is vague. We can say a law is unfair when it targets specific groups of people. We can say it is unfair when it allows for, a great arbitrariness in its application, but it's also unfair when it is so confusing for an ordinary person to really understand what lies within the scope of the law and what doesn't. And I feel UAPA is one of those laws that is all of these things, right? So if we talk about this distinction between unlawful and terrorist associations and activities, etc., one key difference again lies in the bail provision under the UAP. In that, whatever the unlawful things are dealt with by the Code of Criminal Procedure, but whatever is terrorist is dealt with specifically through the provisions under the UAPA, right? So the UAPA provides for us for a specific bail provision to deal with offences of a terrorist nature. Yeah. So so these are also, you can think about how by making modifications to the procedural rights of an individual or the manner in which you prosecute a criminal offense or a criminal trial can itself creep up to defeat some kind of substantive fundamental rights that you are guaranteed under the Constitution, right? Which in this case, the UAPA attacks speech expression, but primarily the freedom of association, which is by banning certain organizations as unlawful or terrorist, and then arresting individuals who are either members of those organizations or who have extended support to those organizations. And then you would look at membership and support also very widely, which is to say, okay, if I have a poster from an event that this organization arranged, right? There was a protest and I came back with a poster, then that will be considered to be support. If I attend a seminar, an educational seminar, that will be considered to be support. If I'm offering legal aid, that will be considered to be support. If I'm reading a fact-finding report, that will be considered to be support. So there is an entire sort of category of offences which are based simply on the confiscation of literature, what comes to be called banned literature, whereas the literature itself is never banned. This is like having the Communist Manifesto or having books by Mao in your house. These are not banned books. They become suspect only on an allegation of association, right? On an association with a particular kind of ideology or an association with an organization itself. So the ambit of criminalization is thrown very wide, very arbitrary, such that anybody can really be brought into its fold. Um, but what makes this particularly draconian, which is something that, say, for example, even something in the IPC, which is the sedition or waging war, which are also considered to be serious offences, grave offences against the state. The UAPA is harsher even than that, which is by way of making modifications to procedural rights, to the powers of investigation, to the powers of prosecution. So, for example, in the UAPA, the courts are empowered to deprive you of the right to a public trial, right? Which means that the trial against you, at least to some extent, can be held away from the eye of the public, right? So that there is no kind of media presence not allowed. Journalists, activists cannot be allowed to be in the same room to witness what is going on in the trial. But the most sort of stringent provision here is the bail provision, which is under section 43D5 of the UAPA, which applies only to terrorist offences and not to unlawful associations. So what would happen ordinarily if you commit a criminal offence and you are arrested for it? Maybe it's theft, maybe it's murder, maybe it's any case of sexual violence or hate speech, etc. What would happen is that you would be arrested, and then at some point before the trial concludes, you would probably apply for bail, pending a final determination of your guilt, so that you can be set at liberty, right? And the principle behind this is basically a liberty interest, right? That at this moment in time, you have not been convicted, right? The allegations against you have not been proven beyond reasonable doubt, right? And so, from the lens of the legal system, you are still to be presumed innocent, right? You cannot be kept in custody as if you are serving out your sentence, right? Because that can only happen once your guilt is actually lawfully established. So, the Constitution now, the right to bail is recognized under Article 21 as an aspect of the right to life and personal liberty. It's recognized as an important element of the right to fair trial, as of the right to the presumption of innocence, which we consider to be so cardinal to criminal jurisprudence. So what would happen under a so-called ordinary offence of theft or murder, etc., is that once you apply for bail, it is the judge who will decide, right, whether to give you bail or not. And in making this decision, the judge will think about your liberty, your freedom, and they will try to weigh that against some needs of investigation or the judicial process, right? So you want to make sure that if I release this person on bail, they are not going to go and intimidate a witness, they are not going to tamper with evidence, they are not going to abscond, they're going to show up in court, things like that. And so in this matrix, the court might also look at, for example, the gravity of the offence that you have been suspected to have committed, right? So if it's a very serious offence, then the judge might be circumspect about granting bail. But that doesn't mean that somebody who is alleged to have committed a very serious offence will not be granted, right? It just means that the judge will take a call on it. They will evaluate factors. And the reason is still the same, because at this point of time, you are a presumed innocent person. Your guilt has not been established, right? So you are entitled to your liberty. So the court under the CRPC will then look at all of these different factors and then decide, okay, now I'm going to grant you bail or I'm going to refuse you. The UAPA bail provision changes the CRPC in 3 respects. Okay. One is, it says, okay, now this is no longer a matter of judicial discretion. Okay. The judge does not have discretion anymore. That if a certain condition is fulfilled, then the judge is bound to refuse bail. Right? They cannot think about other factors. The UAPA itself prohibits them from granting bail if a certain condition is fulfilled. Right? So one is judicial discretion goes away. Now you are no longer looking at the individual to look at their conditions. The law itself prohibits it. What is this condition? Which is really the teeth of the provision, which is if there are reasonable grounds for believing that the allegations against you are prima facie true. Right? So it's not about witness intimidation, it's not about tampering with evidence, it's not about absconding, none of that. Now there is only one determination that the court will make, which is, are the allegations against you prima facie true or not? Now, on the face of it, this feels like maybe it's an innocuous change, right? What does it matter? People who've committed serious offences, that is something that one must factor in when giving them bail or not. But in the UAPA, what that does is that something like determining your guilt is what the trial process is meant for, right? So you go through evidence that the prosecution has adduced against you. You go through, you examine witnesses, you cross-examine witnesses, maybe you will inspect some weapon that has been recovered from the side, some forensic evidence you might want to look at, right? The opposite side also gets an opportunity to cross-examine and see whether all of this evidence actually makes sense or not. Can it establish my guilt or not? What the UAPA does is it shifts all of this process to the bail, right? So now you are looking at, without going into evidence, right? Without going into whether this evidence is actually truthful or not, whether this evidence is actually reliable or not, whether this is something that the court can actually use or not. You are deciding that this person is guilty, and because they are guilty, they cannot be released on bail. Right? So the trial process becomes sort of an appendage to the criminal justice machinery, which is actually where the core of the core of the trial, the criminal justice process is the trial, where you go through evidence and the state has to justify the allegations that it is making against you. What the UAPA bail provision does is to sort of make that less relevant and shifts all of that to the stage of bail itself, right? So now the state does not have to do beyond reasonable doubt, right? We've all heard this phrase that you have to satisfy beyond reasonable doubt, which means that there should be no scope to doubt that you are guilty, that you have actually committed the offense. Because if there is even a little bit of scope to doubt that you have committed the offense, then you deserve to be acquitted, right? Then that means that either the investigation has not been done properly or that you are actually an innocent person who has been implicated in the case. But the state does not have to do that anymore. The state only has to show superficially on the face of it that you are guilty. So, in an earlier judgment in 2019, in what is the infamous NIA versus Vatali case, the Supreme Court had said that at this stage of bail, I mean, what is effectively happening is a trial, but you're not calling it a trial, right? Because the moment you call it a trial, you have to guarantee procedural rights. You have to guarantee the right to cross-examine witnesses. You have to guarantee the right to be heard. You have to guarantee the right to bring your own evidence, to bring your own defense, to contest what the state is saying. But all of that is not allowed, right? But Ali says that you cannot question the evidence that the prosecution has brought against you. you cannot question whether that evidence is truthful or not. You cannot question whether that evidence is reliable or not. I cannot even bring my own evidence if I want to defend myself. Nothing. All that will be before the court at this point is simply the word of the investigative agency. You're not bringing witnesses, you're not bringing any kind of physical evidence. All that is relevant is the word of the investigative agency at this point. So what Batali did was really to in a where the law already made bail highly stringent. What Batali did was to further sort of gag the accused at the stage of bail, so they are unable to defend themselves against the allegations that are coming up. Right? So you basically tied their hands behind their back, and you're saying that you cannot fight back to what is being alleged against. So this is where the Vernon Gonsalves decision becomes relevant, right? Because what it does is that if Batali tied your hands very tightly behind your back, Vernon Gonsalves loosens the grip a little bit, right? So it's not completely overturning Batali. To a large extent, that still continues to hold sway. It still continues to occupy the field. But it's saying, all right, the accused is still not. I mean, but Vernon Gonsalves doesn't say whether the accused can bring their own materials in defense or not, right? That's not as far as it goes. But it does say that if the investigative agency has brought some evidence, then we are going to probe it a little bit, right? We're not going to just take your word for it, right? We're going to see if, okay, is this reliable evidence or not, right? So what the language is that you're going to test the probative value of the evidence, right? You're not just going to take the word for it, you're going to scrutinize it at least on the surface to see whether this can be relied upon or not. So what happens with both Vernon Gonsalves and Arun Ferreira is that one, the Supreme Court says that the kinds of activities that were being criminalized are actually not activities within the ambit of the law. Right? So, for example, providing legal aid to somebody who is arrested and accused of an offense and is facing trial. If you are collecting funds to provide legal aid for them, then that is not a terrorist activity. Right? You can't say that that is a terrorist activity. That there needs to be something more, right? A more direct link with a violent terrorist act, or at least Section 15 of the UAPA, which defines the terrorist act, for this to right. Otherwise, providing legal aid, what is wrong with it? Right? There's another sort of highly challenging practice that the investigative agencies and MHA have been following for a while, which is to arrest individuals under the UAPA on allegations that they are members, but not of an organization that is actually banned under the UAPA. Right? So there are certain organizations that are actually banned under the UAPA. But what investigative agencies would do is to say that X organization is a frontal organization of this other banned organization. Right? So if the PWG is banned, and it's obviously because it is banned, it cannot operate anymore. What it has done is it has now morphed into, or it's trying to operate through the facade of other organizations, and you are that organization, you are that organization, you are that organization, right? So to label any kind of association as a frontal organization of somebody that is already banned. So you don't have to go through that process again. You can just say it, and that will be enough. So in Vernon Gonsalves, the court rolls that back also, right? To say that you can't just call somebody a frontal organization, right? Tomorrow you can't say that Amnesty International is a front of a banned organization, right? You have to show substance to that allegation before you can target Amnesty International. Yeah. So it loosens the grip on that Batali had on us a little bit to say, all right, that there is some degree of scrutiny that we will bring to bear on the kind of materials that the investigative agency is putting forward, and that you have to justify basically the allegations that you're making about links with terrorist organizations or terrorist activities. And on both of these grounds, the court found that there was actually that there was either no substance behind those allegations, or even if there was substance, it was not reliable substance or not reliable materials. Right? And so on this basis, they were granted bail on merits. Right? So this is the merits stage of it. And then, of course, on the K. Najib standard, which is to say that that irrespective of the harsh bail provision under the UAPA, because this is a law that enables prolonged incarceration before a conviction, right? Because we also know that this is a law where once a matter does go to trial, right? Once a court is actually able to look at the evidence properly, only 3 to 5% cases end up in a conviction, right? So which means that most of these cases, the evidence is actually not reliable, but you're able to accomplish the same result by just denying them bail, right? To say you're not going to get bail, right? So these are two major leaps forward that the judgment does, right? To say that you have to establish links and you can't just be taken at face value. We can't just take you at your word. So that is of course welcome. But at the same time, the Supreme Court also set certain conditions, bail conditions, which means that, okay, now that you are being released on bail, it doesn't mean that you can do whatever you want, right? You are still going to operate under some kind of restrictions on your liberty, on your freedom. So if you look at the Supreme Court has set its own conditions, but apart from that, the NIA court, the special NIA court, has also added on to that. Right? So the Supreme Court said, for example, that you cannot leave the state of Maharashtra, which is the same condition that applies even for Sudha Bharadwaj, as we know. That you have to live in this state and you have to work in this state. The Supreme Court also said that both of them need to report to the police station every week to mark their presence. That they must use only one cell phone, and that cell phone number should be informed to the police, and that cell phone must be kept charged and on all the time, and that the location tracking must remain on at all times so that the police knows exactly where you are at a given point of time in the day. And then the NIA court goes even further than that to say that they should not indulge in similar activities while they are out on bail. Now, what is the meaning of the similar activities, right? Does this mean that if Arun Ferreira is a lawyer and he's providing legal aid to persons accused of is that a similar activity? Because apparently that was an allegation that was enough to get him in jail the first time, right? So is that a similar activity? It means that the NIA court is also saying that you cannot have a gathering of people in your house at any point of time, right? So no birthday parties, right? No whatever. If I, as a friend or a relative, I want to go meet these people once they're out on jail after 5 years, I can't do that because there can't be a gathering of people. You cannot contact people who are engaged in similar activities either abroad or in India, and you cannot contact them in any form, right? So these are extremely wide and sweeping and vague kind of conditions, which if you default on, your bail can be cancelled and you can be taken back to jail, right? So and we know that similar conditions of tracking, at least sort of GPS tracking, which has been used on prisoners on parole or prisoners on bail in the US, has been a subject of significant controversy, right? Because this is a violation of privacy, this is a violation of the freedom of movement, this is a violation of the right to liberty. It is a further violation of association because I can't freely meet freely meet people that I am associated with, whether in a personal or a professional capacity, right? So what is really the quality of this liberty now that you're out on bail if you're continuing to be subject to this similar surveillance and similar restrictions on your movement, right? So, and this is coming in a case where the court has said that there is no prima facie case, right, under 43b5 against the two accused persons. But to continue to subject to the same kind of surveillance, even on release from bail, is something that I feel needs to be raised and addressed more going forward. Yeah. Yeah. So, of course, we welcome the release of Vernon Gonsalves and Arun Ferreira, and we continue to work towards the release of all the others that continue to be incarcerated, not just in the Bhima Koregaon matter, but all others under UAPA across the country, and in fact, all prisoners that are at the receiving end of the injustice of the legal system, whether it is under the UAPA or any other law, in fact, for that matter. Yeah. So. Yeah,
Thanks, Radhika, for that very detailed and taking us through really the two dimensions, right? One is you took us through both the UAP, of course, the larger framework of the UAP, and more specifically, what did this particular judgment one and all this mean? As you put it, it loosened the grip a little bit. That's one dimension of it. But the second dimension, of course, which we need to pay very serious attention to, is the nature of the bail conditions and how they continue to restrict liberty in a way which is not in conformity with the constitutional reality. So thank you for that. Before going to Clifton, we should announce that we'll do a translation in Kannada. Very, very important. But is there anybody who feels we should do it or ಯಾರಿಗಾದ್ರು ಕನ್ನಡದಲ್ಲಿ ಅನುವಾದ ಮಾಡಬೇಕಾಗುತ್ತಾ? ಬೇಡ ಅಂತ ಅನ್ನಿಸ್ತದೆ. And next time we'll just take it as a practice to just do it, I think, before we announce it. But yeah, close yours.
Hi. I think Radhika kind of put it on it. This is just. So, I mean, I kind of figured that you're going to go into this in full detail. So I thought I'd just do a couple of things actually. One is UAP. UAP actually is a very old law. It's a statute that was passed in 1967. It's been subsequently amended several times. Congress has very famously passed the law and tried to make it as draconian as possible. And BJP is really upped it in this 2018 amendment, where now they can declare even a single person as a terrorist. So it has a long history. Kannabiran actually have been praised for these kinds of laws. The lawless laws is what we used to keep calling them. And at different points in time, you've had different these kind of party favorites that have been deployed. So if it is NISA that was deployed during emergency, then you saw sedition, you saw waging war being deployed at another point, and now UAP, and of course now they moved beyond UAP. Now PMLA is like their favorite toy. And while this judgment is most welcome, there's the other judgment of the Supreme Court which was passed in that Senthil Balaji's case, the minister in Tamil Nadu.
Sir, there's a request for you to speak louder.
Oh, am I audible now? So there's the other judgment which was also passed most recently around the same time, which basically says that even the basic protections that are there in the CRPC, like a notice, that is not necessary in those kinds of proceedings. So this is like really understanding the Supreme Court is a very, very tough task. And I think a lot of times it's also the judges that are passing the judgments that kind of have some amount of say in terms of how they understand the law. I think now if you look at UAP, I think I've related or complete this. I really don't need to go into it. Bail is a very big problem basically, and pre-conviction incarceration or pre-trial incarceration, that is the biggest kind of punishment that you can have. So somebody is going to be in jail for 5 years, as in the case of Vernon and Arun. Charges are not yet framed. There may be, it's a 20,000 page charge sheet, which is going to take forever to actually for that trial to actually commence. So what this law actually does in effect is that just the process is the punishment. And through the process, you will be in jail and will be denied bail. The law is structured that way. And the Supreme Court was aided by, wasn't that Mishra's judgment, Vatali? Vatali was his judgment? The Vatali judgment of 2019. Kanvilkar. There are all these names I have heard: Kanvilkar, Arun Mishra, M.R. Shah. And you see the judgments, and then you'll get a sense of where we're going with that. So Vatali basically made it impossible for bail to be granted. If you remember, one of the cases where which recently came in the news was Natasha and Devangana's bail matter, where the Delhi court actually passed in-depth kind of analysis of the law and granted bail. And then, of course, it goes up to the Supreme Court. It's in challenge over there. I think that's now been... Anyway, they're still out. But one of the things was like, how is this possible that despite Vatali, you have this kind of order being passed? So what I thought was, I'd probably just take you all through few judgments, because things have slowly kind of evolved. So one of the judgments that Radhika referred to is the Najib judgment. The Najib judgment, basically what it said was the rigors of 43d5, which is that, this prima facie test. That prima facie test, it kind of loses its rigor as the incarceration period increases. So supposing somebody's been in jail, say for 5 years, trial is not yet commenced, or say the trial has commenced, they have 300 witnesses and they're still on the second witness, which means that this trial can go on forever. So what the court actually did, and this was in this Angela Sontake case, the court for one of the first times kind of introduced this thing that if the trial is, if it appears that the trial is not going to take place in the near future, then bail is something that can be granted. Now this is a judgment that was passed on 30th of January 2015. It's one of the first kind of instances where you see this kind of doctrine being deployed. Now, where does it come from? It comes from the entire, from the notion that a speedy trial is also part of your fundamental rights. So, if you are going to be denied that fundamental right, then however grave the charges are, it still cannot mean that you're going to be in jail forever. So, that's broadly where it kind of came from. Now, this Najib judgment is a very, very interesting judgment, and one of the judges who's passed Vernon's judgment, Aniruddha Bose, he also was a judge who's on this bench. So sometimes you'll see it. There are some of these judges who are like one of the judges who I really like, whose judges I'm going to go to, whose judgment I'm going to go to, is Justice Oak, who used to be our Chief Justice and now is in the Supreme Court, and I think Afif's favoritist judge ever. He wrote an article also about the kind of jurisprudence that Oak evolved. I'm only saying this because I remember there's one of the matters that we did here where it was sedition, right? The Kashmiri.
Sedition.
There were 3 Kashmiri students who were charged with sedition. And so they were beaten up and thrown into jail. The Bar Association passed a resolution saying that no one can represent them. So a bunch of 30 lawyers, including Arun, I think was one of the petitioners, came together. We moved a PIL in the High Court challenging the resolution of the Bar Association, because that's in the teeth of another judgment of the Supreme Court which says that no Bar Association can ever pass this kind of a resolution. And it came up before Justice Oak, and he conducted himself commendably in that. In the first instance, he said that this resolution will have to go. And then we figured that even if the resolution goes, there's still a fiat and no one is going to represent them. So then he said, okay, if advocates are going to go from Bangalore to represent them, I'm going to ensure that they have full protection. And this is a matter, mind you, when we are arguing in the High Court, you have people, sitting behind you saying, see, they must be paid by the ISI. It was a packed court, where this thing. But a judge like him, and finally when he passed the judgment in this matter, where he protected the rights of those 3 students, one of the things that he says in this is whatever it is that the allegation is against these 3 students, the fact is that they're innocent until proven guilty, and they have to be treated that way. That is the rule of law. So you have some judges who are, in the sense, they kind of imbibe this. And I think that's why you will see certain judgments passed. And the ideology that they imbibes also represents the kind of orders that they pass. Most notably, I think in the most recent future, Arun Mishra, Kanvilkar, and M.R. Shah. And of course, Mr. Gogoi, who's now sitting in Rajya Sabha, and today actually made a speech saying that the basic doctrine, basic structure doctrine is debatable. So coming back to this Najib judgment is a very, very important judgment. Najib is where the law was laid down, where it said that 43d5, this rigorous kind of a provision that you have, what you know as the prima facie test, that cannot take away from the powers that a constitutional court have to shape relief for bail in regard to bail to people who are accused in UAPA cases. And after it also, of course, it considers Vatali, it looks at all of it and says, Najib, just for your information, has just been convicted. I think it's a life sentence. Najib is one of the accused, where he cut off a bunch of people from PFI, cut off the of Professor Joseph in Kerala. He was one of the accused. Of course, now 3 weeks ago, he's been convicted. But the court basically said that irrespective of that, this is one kind of avenue that is open. So the door that was shut with Vatali, it kind of opens a little bit with this Najib judgment. Then you have a series of judgments that are passed where progressively this entire this denial of this 43d5, which basically is like a lock on bail, that gets diluted progressively. And now of course Vernon in that sense takes it one step further. So you have this Sudesh Kedia's case where again the court holds the same thing. Now the interesting one for me is of course Justice Oka's case in Shuaib, where this is the Tawa Fazal case. The Tawa Fazal case is where the court really went into it in detail. Radhika was talking to you about membership, that you can just allege that a person is a member of, in their case, the CPI Maoist party, and they have some literature with them, which of course will include Mao, Che Guevara. And they went somewhere and they shouted some slogans. And there's a video of them saying, participating in a particular rally. So all of this is put, and these guys are charged under UAPA. The Supreme Court then actually does a very interesting thing. It says, okay, Vatali says that we should not, the charge sheet, as it were, has to be looked at. And just you look at the charge sheet, if the offences are, prima facie, you feel that it's true, you deny bail. Now, this is a judgment where it says that we can go a little further over there. So one of the things that Tawa does, it basically says that you won't hold a mini trial. So now the charge sheet can be anything. The charge sheet can be 20,000 pages. So Vatali said, you look at the charge sheet, there'll be statements. So for instance, you have statements that the police says you voluntarily made, so-called voluntary statements. A voluntary statement basically is a admission of, it's a confessional statement. It has no value in law. Section 25 of the Evidence Act says it has absolutely no value except on the basis of that statement if you are able to recover some fact to make it understandable. Supposing I'm accused in a murder case and I have given a statement to the police saying, yeah, so and so I went there, I did this, and then I went and murdered that person, and I went to this particular pond and I threw my knife over there. And then the police investigates, takes me to that pond, and that knife, the murder weapon, is actually recovered from there. So then to that extent, my confessional statement has some evidentiary value. Otherwise, it has absolutely no value. So the charge sheet has all of these things. So for instance, in Vernon's case, the kind of material that they had is some printout from somebody else's computer, which says that AF may have got so much of money. That's all it is. So if you went by Vatali, all you will do is to say that, hey, the account statement is there, AF is probably Arun Ferreira, so prima facie, case is made out, you will get denied bail. Twawa kind of opened the door on that and said that you can look at it. You can try and see whether actually a prima facie case gets made out. This, in a way, I think, this judgment, one of the judgments that takes it beyond just looking at it is another judgment of Oak. Now, this is an extremely interesting judgment of Oak. This is in 2023, This case, in fact, is quite interesting. This was where a sitting MLA and an ex-MLA were killed, and so you have these people who are accused of that murder. It's a UAP matter. It goes up to the Supreme Court. In that particular case, Justice Oak, it's a bench of Justice Oak and Rajesh Pindar, but it's a judgment written by Justice Oak. What he does, he says that you're relying on all of these confessional statements of these accused, and that's the single basis for you to say that they should be denied bail. And he breaks down every single one of them, and he introduces the Section 25 test, which is not done before, to say that even in this charge sheet, it has this confessional statement. If you look at it just at face value, it says that, yeah, I went, I killed, I did that. But if you were to look at the value of that confessional statement, then it really has very, very little evidentiary value. So on the basis of that, Justice Oak then he goes on to grant bail. And now you have the judgment in Vernon's case. So for me, I think, Vernon's case, in a way, there are 3-4 things that it does, which kind of opens the door a little more, makes it more possible for accused to get bail under UAP, and not necessarily because you spent 5 years in jail. Even before that, you remember also Siddiqui Kappan, who was also charged under UAPM. He got bail, and to the best of my knowledge, it was 1.5 years.
On Najib grounds.
Najib grounds. But Najib grounds is basically prolonged incarceration. If you look at Siddiqui's incarceration, by that logic, it was around 1.5 years. And of course, he gets bail. But Vernon, actually, this particular judgment, I think, is very, very important. One of the things that happened when this FIR was filed, and then you had the first set of arrests. 8 people were arrested, primarily the Kabir Kalamanch people. I think Suresh Gadling.
6th June, 5 people were arrested.
2018.
Yeah.
Rona, Surendra Gadling, Sudhir Davle, then and the Kabir Kalamanch people. So you had a bunch of people, including Romila Thapur, who approached the Supreme Court, saying that, because everyone knew that this is such a concocted story, and you're spreading the web so wide now, anyone is going to be caught and thrown into jail. The Supreme Court dismissed that petition. It was with a dissent by Chandrachud. But one of the things that Romila Thapur, the majority judgment, said was that you are not being, you're not incarcerated, or you're not being, you're not caught in this case because of some freedom of expression kind of a issue. It is because of your association with members of certain organizations. Now that, I remember when we read that judgment, the first thing that came to our mind was, this is like a death knell for them insofar as their trial is concerned. Because already there's a finding from the Supreme Court on this. Of course, criminal courts, you get over it. But this judgment, right at the beginning, it holds that this finding that is there in Romila Thapur's case, it does not in any way affect the bail proceedings or any other proceedings in regard to that. And I think that's a very, very important clarification that judgment does. The second thing that this judgment does is that this notion of membership, what it says, and again this is developing on what Justice Oak says in his previous 2 judgments, is that mere membership also is not enough. So even if you have prima facie material to show that a person is a member of a particular party or some banned organization, you have to also be able to show that there has been some intention or indulgence in some terrorist act. It is only then that it becomes punishable. So that's a second level of kind of dilution that we see. The third is, of course, what Radhika also referred to. The court actually says this, that you need to have a surface level assessment of the what's that language it uses? The probative value of the evidence. Now, this is like a big shift away from Batali. It's a huge shift away from Batali. So basically now this is coded to say that you look at it and you can do all of those things. You can see whether it's a confessional statement, you can see where the letter came from, you can say that, hey, this letter may have his name, but that letter was actually recovered from some third person. So it really has no value insofar as this person is concerned. And in this particular judgment, what the court does very beautifully actually, it looks at the entire evidence that is there against both of them. So it says that there are all these letters, there are 8 letters. So it goes through each of those letters, where that letter was recovered from, who supposedly authored that letter, to who that letter was probably addressed, and then dismantles each and every one of them to say that, see, none of this was recovered from them. So how is it that they are going to be penalized for it? It also looks at the looks at the there are there's an account statement. Again, it says the same thing, that the account statement is just a statement. And it also then goes back to the judgment of the Bombay High Court, where Anand Teltumde, when he was granted bail, one of the things that they tried to use against him was this account statement that, money from so much of lakhs has been exchanged hands. And the Bombay High Court says that, we don't agree with that. So the court kind of affirms it. Then, of course, this thing of literature, that, they have all these extremists, this extreme left literature in their position, in their houses. I don't know. I mean, I think all of us will really be in on UAPA if that's something to go by. But it says that that's fine. That does not mean it translates into anything. So what the court actually did, it looked at every part of this, the electronic devices. What was it that was recovered from the electronic devices? The call record, the call details that they had taken out, every single part. And then the court goes on to say that irrespective, still there is no prima facie case that is made out. So this actually, in a way, one hopes, opens the doors not only for the BK remaining people who are in jail, but also for the others who are charged under UAPA. Yeah, and actually one thing that this court says, which I think is it's a straight comment, where it actually says this, allegations against them no doubt are serious, but for that reason alone, bail cannot be denied to them. So somewhere, in this very bleak kind of situation that we are in, this judgment has some of this kind of findings of law, which to a large extent, have the effect of diluting Batali and probably, opening up the doors of bail for the remaining years. But it goes without saying, I think, irrespective of that, all of these lawless laws, they get deployed variously by various state governments. I think with this particular, this particular fascist kind of time that we are in, this government deploys every law communally and in any which way it wants. So even for instance, demolitions, what you're seeing in Noor, you can use the law and in any which way you want. So you just say, okay, I went there, and now it is information that's coming out that they went there with the bulldozer and the notice, but they were backdated notices. So they will claim now that we gave the notice, and which is why the demolition is fine. So this kind of a criminal deployment of the law is what we are seeing today. And in such kind of a scenario, if you have a judgment like this way, I think somewhere it kind of offers hope. I don't think it can redeem the courts. That definitely it can't do. But somewhere, at least for those who are incarcerated, to some extent, I think some kind of a hope lies for them. So let's see how this goes from here. Thank you.
Thanks, Vipin. I think the idea of how we think of Vernon's judgment in the context of the other judgments, and how this is, I think, to the certain kind of a nice flow, where you also indicated that the way in which it further loosens that grip, as it were, and the idea that what does it mean to do a surface level probative analysis of the evidence? I think that point came across well for everybody, really, lawyers, non-lawyers, everybody. We'll open it out with that, with any thoughts, comments, which everybody has, anybody may have.
How much of a problem is this business of charge sheets and trial court judgments running into thousands and tens of thousands of pages? I remember Mr. Hargopal, he once spoke at the IAC, Chochigala IAC, organized by students, of course. And he was saying that the judgment in the Hargopal case ran into, I can't remember if it's 500 pages or 5,000 pages, something like that. And the level of the standard of English in that judgment was of a level where, the judge didn't have that kind of language. He didn't have the command of English. And so obviously the implication is that it was handed to him and he passed it. Handed to him probably by the prosecution, by the police. How much of this is what you have seen?
Do you want to take 2, 3? Yeah. Please go ahead.
So there was discussion of membership of another organization and whether that itself. So I think the Supreme Court only recently reversed its own judgment in Arun. Right? So if you could shed some light on that for our understanding, that would be very helpful.
Okay, I think we'll begin with these two, and then
I'll take up Arun first. So, in 2011, there were 3 sort of consecutive judgments by the Supreme Court on the same point. Right? Some of these, I mean, not all of these judgments were under the UAPA. Some were also under TADA, but the issue was the same, right? Which is, so remember, all of these laws, you declare an organization as unlawful, right? You are banning an organization. The issue in all of these cases is, okay, once you have banned an organization, is everybody who was a member of that organization now a criminal in the eyes of the law, right? Or must you also show that this person was a member, but that they actually did something terrorist while they were a member, right? So, if, for example, and I'm taking examples that came up during the, consecutive bans on the SIMI, the Students' Islamic Movement of India, which was first banned in 2001 and then subsequently, I think, 8 times after that, and continues to be banned today. There were, in one case, for example, there were about 196, if I'm not mistaken, persons who were arrested for being members of SIMI, with the allegation that they had attended an educational seminar organized by the organization. Or in another case that came out in 2011 Supreme Court case, the issue was, okay, if you have provided medical aid to a member of a banned organization who has actually done a violent act. So in fact, the same Najib case that Clifton was talking about, which is of the chopping of the hand of a professor, it was in that same case, there was another person for whom this issue came up, right, who had provided medical aid to a PFI member who was injured during the attack, right? PFI was not even banned at the time. PFI comes to be banned only last year in September, 25th September, if I'm not mistaken, right? So PFI was not even banned at that time. So is providing medical aid to a person who is a member of a banned organization, is that also unlawful? Is that also terrorist, right? So how far are you going to extend that link of membership? So in 2011, the court said, no, you can't just keep extending that indefinitely. So membership per se is not criminalized, but you need to show that this person actively furthered the illegal activities of that organization, right? So if you have banned SIMI allegedly for being involved in terrorist activities, then everybody who is a member of SIMI will not automatically be arrested under the UAPA. You must arrest only those that were part of that exercise of planning a terrorist activity. So this was all 3 judgments. This was Indra Das, Ranif and Arun, which were decided in 2011, which came to the same conclusion. This was reviewed by the Supreme Court and the judgment came out in March of this year, where the Supreme Court said membership per se is enough. Right? You don't have to show actively furthering terrorist activities or unlawfulness. You have membership per se is sufficient, right? But what is important is that Arup Bhuya 2, which is the review petition, came out in the March judgment this year, limits this interpretation only to unlawful associations and unlawful activities, right? So, like I said earlier, you have unlawful associations and you also have terrorist organizations. You have membership through unlawful associations and you have membership of terrorist organizations. So, this membership per se standard, which we also call the passive membership standard, applies only for unlawful associations. It does not apply for terrorist organizations, and that is something that was clarified in another case that Clifton quoted, which was Twaha Fazal. Right? Because these are separate. Section 10 addresses membership of unlawful associations, 38 addresses membership of terrorist organizations. So Arup Bhuya 2 does not address 38. It only addresses 10. Yeah. Which means that, yeah, if it's a terrorist organization, then you still need to show actively furthering some terrorist activity. I don't
No,
know.
that's, I mean, said it. Just
Yeah.
that actually, this judgment talks about Arubuya, and it kind of summarizes it to say that now the law as it stands, Arubuya, by the way, was passed by Kaju.
All three were.
All three by Kaju in 2011, the infamous Markande Kaju. But that judgment, those judgments saved so many people.
Yeah.
But now Mr. Shah, I think he sat on the
MR.
review
MR
petition
Shah
on
was
this.
the
So basically, this what they've said now, what at least Vernon is kind of interpreting in Vernon, they're interpreting Arun Bia to mean that only if you continue to be a member of that organization even after it's banned, then you are liable to be whatever brought within the gamut of some kind of criminal. Otherwise, not. So let us see. We'll have to see how this is going to play out. But yeah, this charge sheet thing it's become something that they're doing continuously now. So whether it's even CA, the CA anti-CA, all of the friends who are in, the charge is 10,000 pages, 15,000 pages, 20,000 pages. It comes in, push it in carts. So it is an extremely serious problem. But that is something that we've been seeing for a long time. It's not, especially in these lawless laws, Dada, for instance, Pota, Coca, all of this problem has been there. Definitely it is. And also then now, this trial is being held in Pune. That is the biggest 15. And most of it will be in Marathi. So then, how do you even conduct, the trial? So then translations, that it obviously is a big hurdle in terms of access to justice, in terms of having a fair trial, and it's a conscious kind of a thing that is done.
There's this show on Netflix that just came out a few months ago called Scoop, which follows the trial under the MCOCA, the Maharashtra Control of Organized Crime Act, against one journalist. And there's a beautiful shot in that show where, I mean, for a few episodes, the story has been tracking how this person who is in jail, this journalist who is in jail under MCOCA charges, is desperately waiting for her charge sheet, right? Because she knows that is like a sort of like an event in her proceedings that will then decide whether she is set free or not. And there's a wonderful shot where you're in the court and you have these three people lifting a heavy trunk, steel trunk, onto the table, opening it, and then pulling out like reams and reams of charge sheet from there. Right? So, but this is also like I'd say it is an investigative practice that at least, I mean, that has some uses in the law as well, right? Because then if you keep filing supplementary charge sheets one after the other, then you are, number one, prolonging investigations indefinitely, and you are delaying the trial, right? You are not letting the matter reach to trial because you are just taking 5 years, 6 years to just do your investigations. And then there is a certain kind of visual effect also that a 20,000 page charge sheet has on any judge, right? Even a conscientious judge would look at a 20,000 page charge sheet and say, okay, kuch to, there must be something to this, that now, that there is so much material. Um, and, uh, um, and maybe this is not like a generalizable claim, but at least whatever little research I have been doing into UAPA prosecutions, you can see that there is a marked difference between a charge sheet that would come from like a state police versus a charge sheet that would come from the NI. Right? That I would still see like a state police charge sheet that would be this big. But an NIA charge sheet would run into volumes, 6 volumes, 7 volumes, 300 witness statements, 100 pages of bank account statements. And then you can just keep going through that material for as long as you want, right?
Printouts.
Printouts, and they have this special kind of binding which I just couldn't figure out how to open that binding or to get that done again. But there's a special kind of binding for NIA charge sheets that also happens, which only NIA does. There's no other technology. Yeah.
I have a question. Nobel has a question. Oh, you have a question.
Yeah. This is with regard to the anti-slave protests and the Delhi trials that went on. So they basically, the bail hearings now, in some senses, they've all been clubbed together. The bail orders have been clubbed, as in they're not passing them independently for Gulfisha, for Asif Balkan, and so on. So independently, the bail orders are not being passed. So just to understand, this is something that, I mean, is it being done for just for purely purposes of convenience? And where do you find something basis for this in substantive and procedural law, that you're able to, each accused person is an individual in that sense, right? So how do your bail orders remain pending? Say for example, the hearing concluded in February. So how do your bail orders remain pending for so long? And the court openly is repeating and saying that until the rest of the accused bails are heard and pass orders together. So just to understand, is this something that happened in the previous UAPA cases also? Where is the foundation of in law for something like this, to just withhold bail orders for this duration?
Okay, I actually haven't followed. I know. Asif is out on bail, and he's been out for a couple of. 3 of them came out together: Asif, Devang, and Natasha. Yeah, but I'm not the. Yeah, I know that the. On charges there has been a fair bit of issue, but do you know about this bail clubbing? I'm actually not aware of. Yeah.
Basically, they've been saying that they won't pass the orders until all others were still in, apart from Natasha Devangana.
Yeah. Gul is still
Yeah,
in.
yeah. So, and now the judge is
Umar is still in.
transferred.
Yeah.
So,
I'm not aware.
No, just from my memory of this Mutiur Rahman case and Vital Malekudia case. I can't remember which one of the two it was, but they did the same thing. They pulled out Quran or all that. So, but one argument I don't know how to respond. I was wondering how you respond, saying that that lawyer compared it to a kitchen knife, saying it can be a tool, it can be a weapon. If the knife is in the kitchen, it's fine. So, in establishing motives, this is the mindset of the person. These are the motivations. Why did he commit that crime? Why did she commit that crime? Because of this ideology. So, how do you? Because it's
acquitted.
No, nothing. That time they argued it, and then later in the High Court,
He got jail.
Yeah. High Court judges are little like Naveen also got in finally in High Court only. They are a little bit more sensible.
No, but also depends on the kind of offences. Like, for instance, murder cases. It's quite unlikely that you're going to get bail. If you speak legally speaking, even a magistrate court should be able to grant you bail if there is, very case there, or then the sessions court. But the way it is, depending on the gravity of the offence, it usually will end up with you coming to the High Court. But then I know it's very different. It's very difficult to find a kind of pattern to that in that sense. I remember one of our people was in jail on a double murder case, and he was the first accused number 1, but we got bail in the sessions court. Sometimes you just you strike gold with the sessions judge, but otherwise, generally speaking, if the gravity of the offence is such, at least till charge sheet is filed, bail generally is out of the question. Because they would say that, see, we have to investigate, da, da, da. Then once the charge sheet is prepared, then you look at the charge sheet to see the kind of, what is the kind of evidence that they really have on record. And then a decent judge, should be able to, say that fine, now investigation is done, bail can be granted. But sometimes, political ideology and the kind of pressures that are there, it doesn't work that way.
We'll continue the discussion, I think, post the when we get to the. But just to maybe wrap up a little bit, right? I think we're running out of time as well. A quick point is in terms of how do we take this forward is a question which I think lots of people can answer, but I'll just put it to you guys and maybe somebody else can also comment on the point. And links up to something Radhika said, which is the idea that I'm going to speak a lot of legalese. I don't know if people will appreciate it, right? And so it's a fair point. I mean, I noticed that a couple of folks who here did leave. So I assume that it was a little heavy. It's very important, but at the same time it's heavy. So I think it's a challenge for all of us. How do we make this a part of a campaign which we can take forward in a way which communicates to people, as well as takes forward the question of the legalities within court itself. How does it become a issue which is more widely owned or more widely feel the passion that hey, this is wrong, this is completely wrong, this arrest should be happening. How do you create in a sense a certain kind of a mood or which helps get people out of bail or helps displace that presumption of criminality, which there it is in the media reporting, in terms of both the anti-CAA as well as the BK16. Anti-CAA is the most outrageous. I mean, what have these guys done? Why are they in jail? It's a question which you keep asking, and it's there's a lot to be said on this, I know, but just some quick thoughts, right? Or what a campaign can look like going forward, and how people here could be a part of a campaign.
Theses. I think this presumption of criminality that you talk about, it's really not a. It has to be something that's understood and accepted. I remember the rape accused in Hyderabad, when they were encountered, they were killed in a police encounter. You had celebrations across the country. I remember there were celebrations in Bangalore as well, where sweets were being distributed. There was such our police is so I think but the same people will have like crazy amount of skepticism about the very same police when in another kind of a context. So how does one deal with this kind of very paradoxical kind of a situation where the kind of state that is there and the police as its instrument, which will probably just open innocence in numerous cases. Hence this presumption of innocence being so important, that being normalized, I think that itself is where you're having a very, very basic kind of a problem. The second thing is in terms of just the rule of law. To even say this, like celebrating the police, celebrating encounters, celebrating demolitions, there's almost the celebration of lawlessness. So how does rule of law then actually become something which is in a way commonsensical? It's there. See, rule of law is working. So when you say bail is the rule, jail is exception. It actually works. So even in Haryana, the Bajrangi guy, he who's instrumental in the violence that took place there, he got police station bail, which in any way I'd say it's great, but everyone should be getting police station bail today. But the point is that the law is actually working for one section. So all these rules, these norms, all of that. But for the majority of the people, it is not. So I think in a way, some kind of at least some kind of a democratization of society, some kind of these basic norms of criminal jurisprudence, some campaigns around it, with awareness campaigns around it, at least internalizing some of this. Those are things that I feel that are very important. But I think at this juncture there are two things that we definitely need to do. Is to, on the strength of this judgment, is to push for all UAPA persons to be granted bail. Like we really need to shape some kind of a demand around that, and a kind of campaign around that. And second, and where I think we can weave in all of this, all of these ideals, values that one is talking about. And secondly, some of these laws have to go. So how do you actually build that? I think that's And the third is, in terms of this kind of a police state, which actually is there, where the police really the kind of hold it has over society. How do you loosen that? Like in our areas, you can't sit in the evenings and have chai. Sudip also knows. You can't sit and have chai in your areas. Some cop will come and just because you're sitting there, haircut, earring, you have whacked straight up. You'll get whacked over there. So that kind of that real strangled hold that it has over
What are you doing in this area?
Yeah.
How do you do that? So I think these three campaigns, if you can work something around that.
Yeah. I mean, I would. I agree with Clifton when he says that it's really policing and police state is something that we need to take up a lot more seriously. If we look at the kind of conversation one has had around anti-terror laws historically, right? And at least the human rights movement has always called for its repeal, right? That these laws should not exist, they should be taken back, etc., etc. And which is true, right? There's only so much that an MR Shah can do within a UAPA, right? Because even as we talked about, even judges find their hands tied in terms of things that they can or cannot do, right? And let's put aside bias and prejudice and communalization, etc. Even that apart, there is very little that even a conscientious judge can do to rectify what is the injustice in the UAPA, right? And this rhetoric of misuse and that at some point you need a good judge to step in and sort of limit the powers of the UAPA to its lawful boundaries is not something that can be done, right? Because today we might say that that it's problematic for the UAPA to be invoked against the anti-CAA protesters, but we do know that there is a long history, which of course Father Stan has documented in Jharkhand, if nowhere else, about the prolonged incarceration of Naxalite prisoners in Jharkhand, right? So it's important to call for their release, of course, to call for everybody's release, for the law to be repealed, to recognize that there's no such thing as misuse or use that a judge can rectify. It needs to go. But at the same time, the NIA continues to exist or will continue to exist even if the UAPA goes away. And increasingly, we are seeing proposals by the Home Ministry to make even the CRPC look more like the UAPA, right? Or in fact, look more like POTA, in fact, right? Where you're talking about, proposals to make confessions, extrajudicial confessions admissible, to prolong periods of remand, or even these judgments that are coming out from the Senthil Balaji is what you talked about, but so many others that are just like slowly chipping away hard-won procedural rights under the constitution. So the UAPA actually sits in the midst of very coercive institutions like your policing institutions, but also, there's a certain kind of normalization of abrogating privacy, liberty, due process rights, which one can see across the board. So definitely, yeah, on that procedure is not a dispensable or an appendage to justice. It is actually a core guarantee of justice itself. And of course, to also talk about institutions that are a part of the police apparatus and a part of the anti-terror apparatus that would continue to operate with or without the UAPA. Right?
I just abused my chair privilege a little bit to get in two words, which is to say that both what Clifton and Radhika indicated, actually you go to Justice Khanna's dissenting opinion in Indian Double Court. He has the line which frames the entire judgment. He says the history of personal liberty is the history of the struggle of procedure. So that, in a sense, is really the point which he's striving towards. How you get to that broader consciousness around the question of procedure. But I think on the question of what one can do, and perhaps either Manvi or Aishwarya, since both of you are here, both of you are part of the campaign which everybody is a part of, right? And you can see the posters over there which also indicate some part of that the campaign effort. If you can share a little bit about what is being done, And what can be done as far as prisoners are concerned? In terms of, you think we can send letters to them? What are the things which can be done? So we can end on that note.
I can start maybe Aishwarya, you can pitch in. So at the national level, there have been multiple rounds of conversations with friends and family members of those who are wrongfully incarcerated.
Can you speak a little louder?
The reason this is very important is that 5 years, 5 years is not just about the people who are inside, but for each visit when somebody has to, when they enter appearance, and when their family members and friends want to see them when they're being produced before, that's the chance of meeting them. That's the cost that incurs there. The kind how their lives get tied down to one particular city where they're in house arrest or they have been jurisdictionally police wise limited to. So you see, there's a whole family, there's a whole ecosystem of friends, of your workplace colleagues, everything that completely falls apart in that sense. So solidarities and need to be extended to friends, families as well of the people who are inside and of all of the wrongfully incarcerated also. And the one thing is that we've been hearing in all of these conversations we've been having with people, like with the family members, is that they keep saying that it's the letters are sort of one way to stay connected, and newspapers they get a day late and things like that. So this, like simple gestures of writing a postcard of a letter, which may not take more than 5 minutes from all of us, but it really is something that keeps them going and keeps them also reminded that they are in all our memories and all our hearts, and we are fighting the struggle from outside here while they're continuing the struggle inside. So if that is something that can be asked from all of you, there's all of their names, postcards are all right here. We have their addresses, and we are in touch with the lawyers and family members, and through PUCL we can send those postcards, and it's really something very simple, but it's something that will go a very long way when it comes to them. So that's in terms of the messages. And the other thing, I was speaking to one of the friends of Mahesh Raut, Vinayak, and this is something he was sharing, that if people can also write letters to family members who are going and entering appearances, because the kind of emotional turmoil that they are through, seeing their sons and daughters and inside, and like Kulfisha's father's not been doing very well, and so all of these kind of things that are there. So these kind of, we don't have to know them personally, that's not the ask. If you just write a letter to the family members also and to those inside, I think that will just go a long way. And yeah, Aisha, if you have anything to add?
Yeah, there's, so this is a part, just to add a little context, when Father Stan passed away 2 years ago, the National Campaign to Defend Democracy was a platform that brought together about 160 organizations from the country, from trade unions, student groups, um, human rights groups, women's rights groups. So all of them came together, and it started with quite a strong campaign with regular events, explainers, presentations about UAPA, bringing together other accused and acquitted folks from the Adivasi community, Muslim community, and it started with many of these events. But it sort of, because of the number of things that are happening, there was sort of a lull. And again, now in May, it's restarted. What we're trying to see is now that at the state level, at the local level, can organizations also come together to restart? So 2 years ago, there was a Karnataka chapter for the national campaign, for the campaign to defend democracy. So there was a Karnataka chapter. If any of you are interested to join this effort, just share your email address, or just talk to Manvi, me, or Arun, and we can do something soon. So over here at this level, the postcard campaign is just one of the things that we can do. One of the main things that Arvind also indicated is that there's a dearth of information in Kannada. There's a dearth of any of this communication in Kannada. How do we talk about this? There's enough and more horrifying stories of UAPA in Karnataka that a lot of our friends have been working on. So this is something that we can restart. If any of you are interested, please share your names with me, Manvi.
Thank you.